86.4%. That is how many Australian family law judicial officers surveyed in national research said they had never once met a child to hear that child's views. Not never ruled on a child's life. They do that every single working day. Never met one. These are the people who decide where a child sleeps, which parent a child sees, and whether a child is safe. And according to the same research published through the Australian Institute of Family Studies, judges across this entire country meet with children in perhaps 1 or 2 cases a year, 1 or 2, nationally, in a system that exists, in its own words, for the best interests of the child. The child is the one person almost guaranteed never to be in the room. Here is what that looks like from a child's height. In research commissioned through the Australian Institute of Family Studies, children from separated families described asking when they would get to talk to the lawyer the court had appointed for them. One child was told the lawyer would not be speaking to them at all. The answer they remembered was devastating in its simplicity. No, that is not the role, apparently. Sit with that for a moment. A lawyer appointed by a court to represent a child whose role apparently did not include speaking to that child. That is not one bad lawyer having one bad day. For 49 years, that was the system working exactly as the law allowed it to work. Tonight is about the gap between representing children and actually asking them anything. This is All Kids Lives Matter, Stolen Generation 2.0. I am your host, David Smith, and this is episode 7, The Children Nobody Asks. Every fortnight, we take one part of Australia's family law system and hold it up to the light. Tonight, we arrive at the namesake of this entire series, the children themselves, the subject of every single parenting order, and a participant in almost none of them. As always, everything you are about to hear comes from public data, from parliamentary and government-commissioned inquiries, and from peer-reviewed research, the government's own documents, the court's own annual reports, the researchers' own published findings. Nothing in this episode is speculation, and nothing is rumor. If you are new here, welcome. Subscribe, because this series builds fortnight on fortnight, and the story only gets harder to look away from. Before we start, the receipts. Tonight's numbers come from the Australian Institute of Family Studies, from the Federal Circuit and Family Court's own annual reports, from the Federal Register of Legislation, from National Legal Aid, and from a national survey of family law judicial officers, published in the legal profession's own journals, verified, documented, on the record. Every document is linked in the description below, so you do not have to take my word for a single number tonight. Check every claim yourself against the government's own documents, because when we say the children are not being asked, we are not guessing. We are reading it straight out of the system's own paperwork. That is the point of this series. Start at the bottom of the machinery with the independent children's lawyer, the ICL, the person a court appoints to represent a child's interests in the hardest, most dangerous cases. The government commissioned the Australian Institute of Family Studies to study how they actually work. Here is the finding. Only about a third of ICLs, 34.9%, said they often or always had direct contact with the children they represented. 8.1% admitted they never did. Never. Not a meeting, not a phone call, nothing. And in South Australia, that figure hit 26.7%. More than a quarter of children's lawyers who never once made direct contact with the child whose entire life was on the table, represented on paper, asked, never. How was that even legal? Because for 49 years, it simply was. The Family Law Act was passed in 1975. From that day until the 6th of May, 2024, there was no legal duty anywhere in that act for a child's own court-appointed lawyer to ever meet the child. 49 years, 2 full generations of Australian children went through the family courts before Parliament. In the Family Law Amendment Act of 2023, finally wrote into law that a children's lawyer must meet the child and give them a real opportunity to share their views. And even now, there is an exception. The duty does not apply to children under 5. It took this country half a century to legislate a single conversation between a child and the child's own lawyer. Half a century. Now go up a level to the person who actually signs the orders. In a national survey of Australian family law judicial officers, conducted by researcher Michelle Fernando and reported through the Australian Lawyers Alliance and the Australian Institute of Family Studies, 86.4% said they had never met with a child to hear that child's views, which means only 13.6%, around 1 in 7, ever had, even once, across an entire judicial career spent deciding children's lives. The same research put the national rate of judge-child meetings at roughly 1 or 2 cases per year. Across the whole country, hundreds of thousands of children have passed through this system since that survey. The people signing the orders that decide their futures almost never lay eyes on them, not once. Is that just how courts have to work? No, it is a choice, and other countries chose differently. Look at Norway. Norway's Children Act, strengthened in 2013, gives every child from the age of 7 a statutory right to be heard before decisions are made about their personal circumstances, and younger children capable of forming views must be heard as well. It is not a favour. It is not judicial discretion on a good day. It is the child's legal right, written into the statute. Australia, by contrast, manages 1 or 2 judge-child meetings a year nationally and leaves the rest to paperwork. Same kinds of families, same kinds of disputes, same claim to be acting in the best interests of the child. One country asks the child, the other asks everyone except the child. And here is the detail that tells you how deep this habit runs. When the government studied independent children's lawyers, the definitive national study of the lawyers appointed to speak for children, look at who the researchers heard from. 528 professionals took part. Lawyers, judicial officers, consultants. 24 parents and carers were interviewed. And children? 10. 10 children in the landmark study about children's own lawyers. Even the research about listening to children ended up mostly listening to the system. That is not an attack on the researchers. Recruiting children through this machinery is hard, precisely because the machinery keeps children at arm's length. But the ratio is the diagnosis. 528 professionals. 10 children. Even when this country studies the silence, it studies it by asking the adults. So, how does a child's voice get into a courtroom at all? Through paper. The courts order reports. In the last financial year alone, according to the Federal Circuit and Family Court's own annual report, there were 4,074 child impact reports and another 2,717 family reports prepared for final hearings. Here is how it works. A report writer meets the family, sometimes briefly, sometimes once, writes down their impression of the child's views, and that document goes up to the judge. The child speaks to a stranger one time, and their words arrive in court secondhand, summarized by an adult, weighed against the arguments of other adults. That is the machinery. It is better than nothing. It is nowhere near the same thing as being asked. Why do so few children's lawyers do this work properly? Follow the pay. Under the legal aid Queensland scale of fees, an independent children's lawyer is paid $153 an hour. A private family lawyer in the very same courtroom bills anywhere from $300 to $750 an hour, and often more. So, the lawyer representing the adult can earn roughly 5 times what the lawyer representing the child earns. Think about what that does to the market. Experienced practitioners drift toward the money. Children's work becomes the underfunded corner of the profession, noble, exhausting, and paid at a fraction of the going rate. Every society pays for what it values. Look carefully and honestly at what this one is willing to pay for its children. And the underfunding is not some accident of the market. It is a documented hole in the budget. National Legal Aid, the body representing every legal aid commission in this country, told the independent review of the National Legal Assistance Partnership that the Independent Children's Lawyer Program needs $40 million immediately and roughly 3,000 additional grants of aid just to meet existing demand. There are only around 600 ICLs in the entire nation, 600 lawyers for every contested parenting case in Australia where a child needs their own representative. When the program runs dry, courts either appoint nobody at all or appoint somebody with no time to do the job properly. Either way, you know exactly who ends up paying the price. The child does. The child always does. Now for the part nobody in a wig will tell you. The children themselves have been asked what they want. Properly, in 2018, when the Australian Institute of Family Studies interviewed 61 children and young people aged 10 to 17 from separated families, 76% said they wanted their parents to listen more to their views about parenting arrangements. Roughly 2/3 wanted the professionals and services around them to give them space to speak and to actually listen when they did. And they were clearest of all about one thing. They wanted to be heard about their own safety, not to pick the winning parent, not to run the case, just to be listened to about their own lives. That is the entire ask. And the system, as built, cannot manage it. So here is what you do with the next 5 minutes. Share this episode, especially with anyone who works in or around family law, because most Australians have no idea the duty to meet the child is barely 2 years old. Contact your federal MP through aph.gov.au and ask one question. Why does an Australian child still have no statutory right to be heard in decisions about their own life, when Norwegian children have had that right from age 7 for over a decade? And subscribe. We publish every fortnight, we show our sources every time, and we are nowhere near finished with this system. Tonight you heard how a system built in the name of the best interests of the child spent 49 years, never requiring a single person to actually meet that child. Every report, every study, and every statute we cited tonight is linked in the description. Read them for yourself. The children deserve better. The system must change. See you in 2 weeks.